Hello, everybody. My name's Simon Cheetham, as you heard. I'm the team leader with the China IP SME Helpdesk. This slide just tells you a little bit about my background. Basically, I've been working for over 2 decades on IP enforcement issues, and particularly relating to China, and have lived and worked out there for many years. So if you'd like to move on to the next slide. I'm just going to spend a few slides, if I may, explaining what the IP SME Helpdesk does, and then I'll move into the topic specifically about a comparison between China and the EU in terms of intellectual property rights. Excuse me. So the Helpdesk is a service that's financed by the European Commission, which covers 4 jurisdictions: China, Hong Kong, Macau, and Taiwan. I separate those because each has a different jurisdiction, legally speaking. And the Helpdesk provides free initial advice to SMEs interested in doing business in any of those jurisdictions on intellectual property matters. As you can see from the statistic just before we turn over, there have been over 100,000 SMEs given assistance by the SME Helpdesk since its inception. So a big number, and that encompasses training events as well as specific one-on-one consultations and individual inquiries from companies. So if we move on to the next slide, this is our key service. We endeavor to provide a response and advice within 3 working days of receiving any inquiry from a European SME on an intellectual property matter. 3 working days, obviously you have to make allowance for public holidays and so on, but typically we are quicker even than that. So very responsive. And this is the email that you use to send your question to the Helpdesk: question@ChinaIPRHelpdesk.eu. So if we move on to the next slide. To briefly summarize the different services that the Helpdesk provides, these comprise of trainings and workshops, and delivering webinars on various topics related to IP and China. Interestingly also, the opportunity for individual businesses to book an appointment, whether online or in person, for a one-on-one session with our IP business advisor. And these give you an opportunity, or give the SME an opportunity, to actually discuss their particular interests and objectives in a little more detail, taking a little more time. And we find that to be quite a powerful tool for SMEs. We produce a lot of self-learning materials, much like the EU SME Centre, which are available via our website. And these provide some practical tools to help make better informed decisions on IP and China. The next slide just shows a couple of examples of the kinds of guides that you can find, all of which can be downloaded free of charge from the website. And there are numerous different topics covered in these guides. So the chances are, if you're an SME, you'll find something specific to your particular sector and business activity. A more general word about the IP SME Helpdesks. China was the first helpdesk. It was founded back in 2008, but since it started, it has, in a sense, bred additional helpdesks, because it has been a very successful tool for SMEs looking for support in intellectual property. And that led to the establishment of the Southeast Asia IP SME Helpdesk next, and then the Latin America Helpdesk, and currently we have both the Africa and India Helpdesks too. There is a traditional European helpdesk, IP helpdesk, available to SMEs as well. So now there is a pretty broad geographic coverage through individual helpdesks in most parts of the world. So for international business activities, we think that's a great help. And these are the different ways in which you can stay connected with the IP Helpdesk and learn about the various events that are coming up and other useful information that might be helpful to you. So that is, in a nutshell, what the Helpdesk is and does. We have a centre in Beijing, and we have a centre in Brussels as well. And having explained briefly what we do, I'd like to move on and talk about the topic we're here to address today. Basically, I'm aiming to cover intellectual property in China and the drive for innovation, and then give a comparison between the China and EU IP systems. This is an overall comparison, not intended to drill down into finite detail, but to give a sense of the differences between the two regimes. And then talk a little bit about intellectual property for an evolving market. We've already heard Alessio and his team talk about some of these issues and how to consider collaborating with Chinese partners with care. And finally, just a couple of tips and takeaway comments to conclude. So if we move on to the first slide, understanding more about the reason that China is where it is today is really the main theme of this slide. As we've heard, you can't look at one market in isolation. Goods and information flow quickly from one country to another country. And we've heard much already said about the Chinese economy. It's the largest exporter in the world, and it's by far the largest market for some products such as electric vehicles. The first gigafactory that Tesla built was outside the USA, was in China, of course. China needs the continued growth that it has been generating to become a medium-level country in terms of GDP per capita. And that means that China needs to double its GDP, 2020 GDP, again, to achieve the status by 2035. So that's a big ask. As we're aware, China has a top-down style of governing or government. It set out its 14th five-year plan, centering on what they termed as a dual circulation strategy. And that was first articulated by President Xi Jinping in May 2020, as China planned its post-pandemic economic recovery. And that is growth driven by a strong domestic demand combined with exports based on advanced manufacturing. In fact, chapter 5 of that plan describes a plan for building a digital China with 7 core industries: cloud computing, big data, the Internet of Things, industrial internet, blockchain, artificial intelligence, and virtual and augmented reality. And there are 10 areas where that should be applied in China, like smart transportation, smart energy, smart manufacturing, smart medicine, and a smart government. So in this context, changes are being made to IP laws in China, and this is leading to a steady upgrading of their intellectual property rights regime. There seem to be 2 main factors that we can detect driving this change, and one is the accession to trade agreements, particularly the World Trade Organization TRIPS, or trade-related aspects of intellectual property rights, and bilateral trade agreements to enhance growth through trade, but also a recognition in China that innovation is increasing, a way to increase the value of their GDP. And increasing the value is a key component of growth. So innovation, they've recognized, can only flourish under an effective IPR regime. I think just mention one other point in relation to that. Indigenous innovation in China is a strong focus for them, and that's seen as enhancing original innovation through co-innovation and re-innovation, based on the assimilation of imported technologies. So what does that mean? Well, the China government has warned against simply blindly importing foreign technology without plans to transform it into Chinese technology. The concern being in China that the importation of technologies without emphasizing the assimilation, absorption, and re-innovation is bound to weaken the nation's indigenous research and development capacity. So with that context in mind, let's take a look at the China IP regime. So if we can move on to the next slide. The theme on this slide is really big developments. We've already heard some references to this, but in the last 5 years, for example, you've seen the restructuring of IP registration and IP management and enforcement, the governing bodies for those in China. And this has all been part of a bigger reorganization announced way back during China's two sessions meeting in 2018. At that time, they put both the State Intellectual Property Office and the China Trademark Office under the China National Intellectual Property Administration, or CNIPA. In the 2023 two sessions meeting in March, they announced that the CNIPA was being moved directly under the State Council. So before, it was administered by the State Administration for Market Regulation. However, although the CNIPA has been moved under the State Council, the law enforcement duties remain under the jurisdiction of the comprehensive law enforcement teams for market supervision, with an element of guidance from CNIPA. What does that mean? Well, it means for people who use the administrative support for enforcement action, we'll find that there has been little on-the-ground change following the CNIPA's move under the State Council. The State Council explained that moving the CNIPA under them was to expand high-level opening up to the outside world, to accelerate the construction of an IP power, and to comprehensively improve the level of IP creation, use, protection, management, and service. And then in March this year, the CNIPA issued the National IP Administrative Protection Work Plan, focusing on 14 areas like cracking down on irregular patent applications and malicious trademark registrations, and improving guidance on trademark protection and enforcement cases, and strengthening foreign-related IP protection. And in May, they released another plan focusing on, again, malicious trademark registrations. And in July, the CNIPA released the 2023 outline for building a powerful IP country and implementation promotion plan of the 14th five-year plan, which just rolls off the tongue. And this included plans to complete a new round of trademark amendments to the patent law enforcement regulations, various copyright enforcement regulations, some anti-unfair law and supporting regulations, measures for the protection of IP rights at exhibitions, and introducing a distinctive examination of designs and novelty examination of utility models. And then finally, on the 13th of August, the China's State Council released, as Alessio mentioned, the 24 new guidelines to attract more global capital and further optimize the country's business environment for multinational corporations, with IP-related measures from that related to strengthening the administrative protection and enforcement of intellectual property rights. A lot is being said about changing, improving, bolstering China's intellectual property rights regime. So with that in mind, perhaps we can move on to the next slide. This just gives you a snapshot of the kind of issues that the IP SME Helpdesk receives in terms of inquiries from various EU SMEs. As you see, the vast majority of cases tend to be to do with trademark issues. General issues accounts for nearly 30%, and that tends to be to do with an overall strategy question. So if an SME is coming to China and they want to have perhaps some advice and input on how to develop a strategy relating to their intellectual property for China, and that's where that falls under. Just one other comment relating to that, and we find that encouragingly, between 85 and 90% of all the inquiries that we receive at the help desk relate to preventative issues rather than enforcement issues, and that's tremendously encouraging. What that means is that we feel we are reaching SMEs early enough to be able to provide the information and support to help them do the right things, rather than having to come to us when something's gone wrong and they need to take some sort of enforcement action. So now perhaps we can move on and we'll take a look at some of the specific differences between China and Europe in terms of the intellectual property regime. So China and the European Union member states are both members of WIPO and parties to various international agreements on protection of IPR, namely the Paris Convention, the Berne Convention, and as I've mentioned, the TRIPS agreement. So the scope of IPR protection, meaning the types of rights and the duration of protection and the geographical extent of protection, and in fact, the basic requirements for protection are in principle the same in China and in the EU. But there are some obviously detailed differences, and that's where it is useful to be well informed. So in China, in general, only registered intellectual property is protected. If you're not formally registered, you have not formally registered your IP in China, then generally you cannot enforce your rights in China. And although copyright, in theory, does not need to be registered in China, in practice, registration is available and it's advisable because Chinese courts require registration of copyright or notarized proof of copyright in order to accept your case. But compared with Europe, you might be able to enforce your intellectual property rights without registration under certain circumstances, where proof of earlier use in a European country market might make it sufficient to enforce unregistered rights. In China, intellectual property is only protected from the date it's registered. So what that means is you can only start enforcement action once the registration of your intellectual property right has been registered. And that's distinct from Europe, where there is some conditional protection granted from filing. So you can start enforcement as soon as you filed an application, but just bear in mind if the application is rejected, then the enforcement efforts may not be recognized, or if it's partially rejected, the scope that you can enforce that right may of course be reduced. Intellectual property rights are territorial, both in Europe and in China. What that means is that if you register intellectual property in China, it is only protected in China. And similarly, if you register your IP in one European country, it's only protected in one European country. So that's just a common feature. In terms of patents and trademarks, these can be extended internationally. China is a party to the Patent Cooperation Treaty and to the Madrid system administered by WIPO. So that can simplify the international extension procedure, both for trademarks and for patents, because it means that the formalities for other jurisdictions can be done at a local intellectual property office. And that's the same for China as well. In terms of the registration process, there are some detailed differences, obviously. In China, invention patents, utility models, design patents, and trademarks are registered at the CNIPA. I mentioned the copyright registration is not compulsory, but recommended, and that's registered at the China Copyright Protection Centre. Geographical indications can be registered with the CNIPA trademark office as either collective or certification marks. In the EU, patents, utility models, designs, and trademarks can be registered in every member state separately, but they can be protected in several member states via a single procedure at the European Patent Office. And trademarks and designs can be protected throughout the EU through registration with the EU Intellectual Property Office. Copyright in the EU, of course, does not require registration, but you are advised to keep a record of the authorship and the date of the work of art to enforce your copyright successfully. And geographical indications are registered in the EU at the EU level with the European Commission. So if we could just move on to the next slide and take a little bit of a closer look at trademarks. Just a bit of background to give a sense of context. Last year, there were 7.5 million trademark applications filed in China, and nearly 6.2 million trademarks registered in the same year. Huge numbers. And there were just under 6,000 applications for international registrations via the Madrid system from Chinese domestic applicants. And that actually made China the third ranking among all the contracting states. Also in 2022, the number of trademark applications in China from abroad amounted to just under 212,000. And that was a decline of nearly 22% year on year. Where do who are the top countries then who file in China? The top EU countries are Germany, France, Italy, Netherlands, and Sweden. They tend to file the most. So having a look at the differences between trademarks, as you see, there are some differences between what can be registered. In China, visual and sound trademarks are practically recognized. So you need trademarks made up of words or graphics or a combination of both, or color combinations and so forth. In Europe, those characteristics are also recognized, but also scent marks. So that's a difference. In China, you are advised, although not required, to translate word marks particularly into Chinese in order to better protect your brands, and also to help you or help SMEs appeal to local customers. Just a quick mention, there are 3 common ways to choose a Chinese trademark name, and I'm sure the EU SME Centre can also help with this, either by translation or by transliteration, so you get a similar sound, or a combination of the 2 methods. So ideally, if you can use a combination of the 2 methods and have a successful meaning as well as sound, then that will give you the optimum result. Please note, you do need separate registrations for Chinese characters and for marks in Latin or Western script. You can register via the international system in China. So you can register either via the Madrid system or directly with the CNIPA. Please note that China divides goods and services into additional subclasses. So if you have a complex range of trademark applications, then it can be advisable to register those direct with the CNIPA in China rather than through the Madrid system. And although China adopts the Nice classification, which is the same as the Madrid system, so you have 45 different classes, each of those 45 classes is, as I say, subdivided into subclasses. And that can be complicated because they can be very focused, and it is very easy to make a mistake when registering your mark and not exactly getting the coverage that you would desire. So the advice is to really get some help, get some professional help when registering your marks in China. So if we move on to the next slide and take a look at the comparison between patents in China and Europe. So in China, an invention patent takes around 3 to 5 years typically to register, and is valid for 20 years. A utility model patent, which can be valid for 10 years, takes normally less than 1 year to be granted. In Europe, the time for registration generally varies from each member state, so it can be variable here. In China, if an invention patent is made in China, then you need to first apply to the patent office there for a confidentiality examination if you're going to make your first application to register or file a patent outside of China. And if you don't do this, then you can't subsequently obtain a patent for China. So it's worth bearing that in mind. There's no such issue with Europe, with the EU. Utility models are a very, very common tool in China. Basically, they are designed for a new technical solution, which may involve the shape and or the structure of a product, and which are fit for practical use. They're granted faster, and they require no substantive examination, so they cost a lot less to obtain as well. In Europe, utility models are a lot less common, and not all European countries offer this form of protection. And finally, you can get patent convention treaty filing route for China by filing directly with the you can register directly with the CNIPA, or you can use the patent cooperation treaty filing route. Using the PCT route gives you considerably more time, around 18 months, to consider the viability of your invention in China. So it can be advantageous to use the PCT filing route from Europe. We move on to the next slide. I thought this the statistics not particularly new, but they show the trend which does continue, and which serve to emphasize in a way the usefulness of utility model patents. If you apply for a utility model patent, chances are you will get this early. And what commonly happens in China is a parallel filing for an invention patent and a utility model simultaneously. And then once the invention patent is granted, the utility model can or has to be abandoned. And this gives you the faster protection and just gives greater options. And it's widely used, as I say, for patent registrations in China. Last year, the CNIPA registered just under 800,000 invention patents, and this was an increase of nearly 15% on the previous year. And in the same year, last year, there are around 2.8 million utility model patents granted in China, and that was a decline of around 10%. Out of that 2.8 million, only around 6,500 utility models were from abroad, and that was a decline of nearly 6% on the previous year. And which EU countries are finding the most utility models? Germany again, France, the Netherlands, Italy, and Sweden are the top filers. But it does show, the figures do show that in general, the EU makes inadequate use of the opportunity to file utility model patents in China, and we may be missing out on that. In May 2022, China acceded to the Hague system for the international registration of industrial designs, making it possible to apply for international design protection in China, which will make life easier when applying for a design patent there. If we can move on to the next slide. So taking a look at what other rights are available in China. I mentioned designs just now. Designs have to be registered as a design patent in China in order to be protected. Whereas in Europe, unregistered designs can be protected for 3 years. In China, if you register your design, you obtain 15 years protection. Whereas in Europe, registered design gives you the exclusive use of that design for 25 years, either in the whole of the EU or in the state where it was registered. Copyright in China is protected from the date of creation, but as I mentioned, it is really advisable to register copyright to ensure that practically you can use the copyright when you need to enforce that right. And you register, as I say, at the Copyright Protection Centre in China. Just a word about databases in China. Databases can be protected with copyright as compilation works in China. So to qualify, a compilation work should be a collection of data and be arranged in a way that adds to the value of the data, either through the selection or arrangement of the data or the originality of the presentation of the data. So protection under copyright in China. In Europe, databases can be protected under copyright too, if they are original intellectual creations. And the protection in Europe tends to focus on or be applied to the structure of the database rather than on its content. Also, algorithms in China, which are integrated into a source code of software, are protected by copyright, as are 3D and computer-aided design files, which are also protected by copyright in China. And this is similar, in fact, to Europe. And finally, trade secrets. In China, only trade secrets which are undisclosed to the public, that give some sort of competitive edge, and are protected by physical, technological, and contractual measures qualify for trade secret protection. And in the EU, well, an EU directive has been issued which is aiming to harmonise the way national laws offer protection for trade secrets, and to introduce a uniform definition of trade secrets as well. But the principles generally apply in any country on trade secret protection. You'll find similarities wherever you go, and that is that you have to be able to demonstrate that you have taken steps to keep your secret, and that it has some sort of commercial value. And only if you take these steps will you be able to protect it in that way. So let's take a look at the next slide, which is on a comparison on enforcement between China and the EU. I think probably the biggest theme to be aware of in China is that it tends to be the responsibility of the intellectual property right holder to collect evidence in China. In the EU, the infringer can be ordered to provide information and evidence to the court. So the courts can help the IPR holder collect evidence by ordering the suspected infringer to provide relevant information and evidence. But in China, in most cases, evidence has to be collected by the intellectual property rights owner. And for foreign companies, be aware that it must be notarized by a Chinese notary public, otherwise it won't be accepted. But I have to say that there are changes on the horizon. For one, under the revised trademark law, in certain circumstances, the infringer can be ordered to provide evidence to the court. But I would still say that the general theme is you have to prepare your own case as far as China is concerned. In terms of the time limit for evidence, in China, the court sets time limits for producing evidence in the preparation phase for the court hearing, and that can be negotiated between the parties, but it needs court approval. And as I say, documents must be in Chinese and notarized. On the notarization and acceptance of documents, if there is no delay, then in November this year, China will accede to the Apostille Convention, which will simplify the legalization procedure and just help foreign companies in presenting evidence to courts. But it's early days. Next month, they should accede to the convention. If that works, then we will need to see how they implement the accession in practice in China. But hopefully things will improve in that respect. In Europe, you can present evidence during the entire court proceeding. So that's quite a difference. In terms of enforcing trade secrets, in China, you can enforce your trade secrets in court and with the administrative authorities, at least in theory, as trade secrets are protected under the civil and criminal law and also under the administrative law. In Europe, you have to go to court in order to protect your trade secrets. In terms of other enforcement routes, administrative actions are a great asset or resource available to, particularly to SMEs. They provide the resources of the Market Supervision Administration in China with its presence in cities and municipalities throughout China, and provide a relatively fast and cost-effective way under trademark infringement and copyright infringement cases to go to the authorities and complain and have some sort of action or intervention taken on your behalf. They'll carry out raids, they'll confiscate infringing goods, and then impose fines. And the fines are becoming slightly more realistic these days, which is good to see, but you will not receive any compensation or damages using this route. And finally, on copyright cases, China has developed quite an efficient system for dealing with online copyright infringements by working through the internet courts that have been established in different locations in China. And these provide a faster, more efficient means of having your case heard. So proceedings from the filing of a lawsuit to all the way through to the announcement of a verdict are available online via this resource. And that obviously saves time and traveling costs, particularly for EU SMEs. So I've stormed through a comparison between China and the EU. As I say, the intention is to give you an overview rather than drill into the finite details. So I hope that at least demonstrates that there are significant and notable differences between the two jurisdictions. I have a couple more slides, and I could never finish without perhaps revisiting a topic that the EU SME Centre has also been talking about as well. And that is finding the right partner. We've heard people talk about this as well. So, I mean, recognizing that you need to protect intellectual property while having to deal with contractors, partners, regulatory authorities, and a host of other parties is actually, it's a constant challenge. One tool that is useful to SMEs in particular is the use of non-disclosure agreements. They're widely recognized by Chinese courts, and we suggest should be used in really every business dealing with a third party, no matter how big or small, and include non-disclosure agreements in contract manufacturing agreements as well. Thorough documentation, requiring strict procedures when disclosing and receiving confidential information are also very, very important. And they are in fact essential when you need to seek to enforce a non-disclosure agreement in case something goes wrong. You can use non-disclosure agreements really to establish a level of IP protection right at the outset of becoming involved with a third party in China. So a fabulous tool to use. We've heard mention of background checks and due diligence, also vital. There is a lot SMEs can do for themselves, and some of these steps can be very simple and straightforward. You've heard already that you can check whether a company has been legally registered in China. Do that so you know that you're dealing with a legitimate entity. It's always worth checking whether payments to that company actually go to the company you are contracting with and don't, for some reason, get sent to an alternative party. When you're checking the registration, business registration, it will give you their scope of business. So do check their scope of business. Do they actually produce the product and provide the service that you want to partner with them on, or that they want to sell to you? You can also, again, free of charge, carry out a check of their intellectual property rights via the CNIPA. And this is well worth doing. If you do a search and you find that the company you're about to partner with has, for some reason, registered hundreds or thousands of trademarks, and you recognize some of those names as being quite famous, then that should really be a red flag. So just be careful. You can also take a look at the patent registrations too of companies in China. This information is accessible to anyone who wants to do business there. And if you are solidifying a relationship with a potential partner, always worth asking for a customer list. They won't necessarily always provide one, but well worth asking for a reputable customer list and also some sort of evidence of actual business transactions as well. So you get a more concrete feel for the robustness of the partner you're looking to deal with. And just a few more points on the next slide about moving into China. Again, we've heard a few comments on this already, but once you have selected a partner, then structuring any agreement with them, particularly if it relates to technology transfer, which is often the case, is critical to effectively protecting your intellectual property rights. And the intellectual property rights risk that you'll face will vary depending on whether you're licensing or setting up a joint venture or a wholly foreign-owned enterprise, or indeed whether you are following an EU customer, as we heard mentioned, into China because they've asked you to go. So I would suggest that while it may be the easiest, that licensing to an unrelated Chinese company, for example, through contract manufacturing, generally gives the least control over intellectual property, but does give you the option to use multiple suppliers. So you can use a modular strategy and using different suppliers perhaps to source different components of a product. So no single supplier can make the one product, but licensing would be at the top, at the head of the arrow really on this little chart. Setting up a joint venture, often very helpful because you're making use of a local partner's contacts or some existing facilities, or maybe it's required by the foreign investment catalogue. And typically a joint venture setup will require the production of a completed product for efficiency reasons. But you will face the challenge of transferring technology to the joint venture while preventing intellectual property leaking to the joint venture partners. So that's difficult. And so it's important to be creative and to not let the deal stop the protection of intellectual property. You have to clearly define the roles, both of the joint venture and the joint venture partner. For example, keep critical design work or manufacturing of critical components in a separate, maybe wholly owned subsidiary or even offshore, if you can do that. A joint venture partner with strong local contacts or a sales network could be the authorized distributor of the joint ventures products, for example, but otherwise more limited in its activities. So just be aware, the theme here is that there's a danger of IP leaking via a joint venture partner in these setups. Wholly foreign-owned enterprise, it provides less risk. It gives you the greatest control over a wholly owned subsidiary, but obviously requires the biggest investment and time and effort to establish. In a wholly foreign-owned enterprise, the focus tends to be more on preventing intellectual property leaking via employees or even business partners. So just you have to perhaps be aware of that and target your efforts accordingly. Normally in a wholly foreign-owned enterprise, the foreign party would want to own all the improvements made by the Chinese party when products and services are improved for the Chinese domestic market in particular. So you have to use confidentiality and non-compete agreements for the employees who may be knowledgeable about the technology that goes into the wholly foreign-owned enterprise setup. So again, a different set of risks there. As we've heard, following an EU customer can be a less risky option, as you are able to follow on the coattails, perhaps, of a larger European business that's bringing the SME into the China supply chain, and perhaps follow the advice and the guidance that they are able to provide, and almost work under the umbrella of their setup in those circumstances as well. So that's an ideal situation if you are fortunate enough to be able to avail yourself of it. So I think I'm perhaps running slightly over, so I'll just close by offering a few takeaway points. I think this theme has come across anyway this morning on more than one occasion, and that is that it's essential really to take a deliberate, not an opportunistic decision to go to China as part of an overall internationalization effort by the SME. Opportunistic decisions often go wrong. So a deliberate, planned strategy is really the way forward. As you've heard from the comparison we've just discussed, you can't assume the law is the same as in the home market. So it's important to know and be aware of those differences. IP registration is more or less everything in China. Why I mentioned earlier in the presentation about being glad that we're reaching so many SMEs early in a preventative way to give advice and information about IP in China. This is really because if caught early enough, it's ideal for an EU business to seek to register their IP even before they go to China, to make sure when they arrive, they're doing so safely in the knowledge that they've already got rights registered there, and they're not going to be immediately thrown into the difficult situation of having to contend with some intellectual property rights issue on arrival in China. So really, the earlier the better, and the more the better as well. Although there are some changes afoot regarding how broadly you can register your rights, so keep an eye on the China IP SME Helpdesk information. Make sure all the rights are in your name, not a local partner. I know some people trust a local partner 1000%, but nevertheless, at some point in the future, there can be an issue, and not all of us are fortunate enough to know the local partner that well. So really, the professional and best business decision you can make is to register your intellectual property rights in your name. Don't have somebody do it for you in their name on your behalf. It's not a good practice. Do they need to know? Well, you may be very proud of, and we've seen some marvelous innovations and technologies and services, particularly at trade fairs from EU companies, But sometimes the excitement about delivering a new product can perhaps overtake, and a little too much information can be disclosed. So it's good to just hold back and be aware that if you have innovative ideas and you have secrets and other confidential information which give you a competitive advantage, consider whether you actually need to impart all that information when you're discussing business and doing business in China. If you don't need to discuss it or divulge it, then don't. You keep it for another time. So on that note, I'd say the last point is, if you're looking to go to China, then in addition to contacting the EU SME Centre, we collaborate closely with the EU SME Centre. Do feel free to reach out to the China Helpdesk, and we'd be glad to talk to you specifically about your IP needs and what you can do there. So that wraps up my presentation. I'm happy to take any questions.
Yeah, thank you very much, Simon. Thank you very much for the very interesting presentation. I noticed that we have a relevant amount of questions coming from the online audience, some of which are extremely technical. So I would like to take the chance to start by mentioning that you have the opportunity to post these questions directly to the experts of the Helpdesk. So please take advantage of this opportunity and do that yourself. And I would like to also mention that we strongly cooperate, the Helpdesk and the EU SME Centre. We have joint activities, joint events. We're going to have a webinar on trade fairs tomorrow as well. So it is extremely important that all these questions are posed to both entities, so that we can provide comprehensive service to the enterprises. So without further ado, we are very late on our schedule, so I would like to take maybe just a couple quick questions coming from the audience that we can directly answer live. So I see a question from Sarah. If you could please pass the microphone to Marco.
Thank you very much. Very interesting and detailed information. And I like very much the way you compare China with Europe. Because let us understand more. I have just one question concerning the first to file issue. Okay. So can you please tell us more about this practice? Because as far as I know, this is very common, actually, that a company is going to China, they find their product, their trademark already registered. Okay, so I would like to understand if this is the case and how, because although you are protected, and actually we conducted a survey recently, and the Italian companies told to us that actually this is an issue that has not the same importance as before. So it is improving in China, the environment and so on, but still I do believe that it's very important, because we address today's forum to the SMEs. So I do believe that it is very, very, very important to address this matter. Thank you very much.
Certainly, yeah, and great question. Yes, China is a first to file jurisdiction. So what that means is that you need to get your registration filed before anybody else files a similar registration. So once you're in the queue, then you're fine. But unfortunately, as I say, it's a first to file jurisdiction. So that's why we hope to reach as many businesses as we can before they even head to China, and encourage them to seek to start the registration process if they're considering China as a business destination, so that they can get in early and before others. There are issues about malicious trademark registrations. This has been a key topic for over a decade in China. The European Union has raised this issue repeatedly with China over the years. And to give credit where credit's due, China is specifically addressing the issue incrementally. So they are looking to provide more support to make it easier to identify malicious trademark registrations. There are ways or procedures now available where if it's demonstrable that a entity in China has registered numerous marks in bad faith, then the CNIPA can step in to revoke the registrations. But practically speaking, if you're an individual entity, a small business, you're just setting out, you don't have many spare resources, the cost-effective way to deal with this issue is to get in first, because you do not want to be tied into having to try to contend with an earlier registration, which may have been made in bad faith, but which you then need to struggle to prove was made in bad faith, and that can be difficult. I say the law is the law in China, and it is the first to file jurisdiction. So the ideal solution is get there first and register early, and that will prevent the problem.
We have another question from the audience, please.
Yes, thanks. I've heard that Chinese partners frequently now ask for localization of IP in China. I think it means that sort of your local company needs to own the IP rights, the locally registered company in China, although I'm not quite sure. They often ask for this in exchange for subsidies or preferential treatment, tax breaks, these kind of things. Is this a good idea? Or, I mean, what are the implications of having your local company owning the IP? I suppose it goes beyond registration, at which you said makes sense in any case. But what do they mean when they say, please localize in China?
Yeah, I think it's not a good idea overall. Your intellectual property is yours. And so if you allow a local entity to register what is your intellectual property in Europe, in China, and so that they own the rights to it in China, then it puts you in a very difficult position. So, in some cases, it may be a negotiating tactic. Yeah, there may be pressures for subsidies and similar in China sometimes when you're dealing with these situations. So you need to, ideally you retain ownership and you register your rights in your name in China. If you feel you have no option but to reach some sort of compromise, then you might want to set aside certain rights that you feel you can afford to use in that way in order to reach some sort of agreement with the subsidiary. But bear in mind, once you allow the subsidiary, and again, I'm not clear about whether you own the subsidiary or whether it's a wholly locally owned entity or how that works out. But obviously, once the subsidiary owns those rights, then you have lost control of that aspect of your intellectual property in China. So yeah, just be very, very careful. I mean, you far better that you are able to register your own rights in China and you retain the ownership, and then whether you have some sort of arrangement where they can license the intellectual property at a discounted rate or some other way in which they could access those rights, then that would be up to you to try and find the best, the best way forward. But the theme is that you need to retain control of your intellectual property rights if you're to have a long-term future in China. So yeah, just be careful with that. There have been some difficult cases where local companies have stepped in and registered rights, assumed control, and then obviously have been able to dictate the access to the China market. But it can go beyond that as well. these companies can also export products. So, what you think may be confined to China may ultimately result in products coming out into another market where, you are also having to compete with them as well. So there are bigger implications to handing over rights to your intellectual property to another entity in China. So if at all possible, you should retain full control.
Thank you very much. Let's take a final question from the audience.
Yeah, I don't want to take, but maybe I'll just a follow-up question to this. I mean, the technology import-export regulation. What if, for instance, I have a subsidiary in China and I have full control of it's a WOFE, I have full control of it. What if I have an invention patent filed with a subsidiary? What could happen? Because there is this regulation, there is a catalog for restricted and prohibited technologies that cannot be exported again from. So what happens if at some point the IP that I own in China through my subsidiary I want to use this IP in other markets? What's the impact of this regulation in practice? Is it an issue in your experience?
Yes, it can be. Yeah, I mean, again, much is going to depend on how the entity has been set up and the agreements that are in place. Because if you are working with a subsidiary and there are IP issues with that subsidiary, you will have to fall back ultimately onto the agreements that you have in place between you and the subsidiary and relating to the use and control of the intellectual property that's developed by the subsidiary as well. So the issues, and these things do happen, often is overlooked the creation of additional IP resulting from the development work that may have been undertaken by the subsidiary, for example, can sometimes be overlooked. And there's nothing in an agreement covering those aspects. And that's, once you get into a grey area like that, then it's very difficult to control or even enforce those rights. So the key there is to ensure that you are in contractual control of the intellectual property as it's developed and its use. So that again, if the intellectual property is to be exported or to be sold domestically, you will retain an element of control through the contractual arrangements that you put in place, covering those intellectual property rights. Unfortunately, it's not necessarily an easy thing to do, and people do get it wrong. So you just need to take great care in preparing the contracts that you have covering those points.
Yeah, let's take the final question of the panel.
Thanks. Yeah, very interesting. I'm also meeting a lot of SMEs that are interested in entering the Chinese market, mostly with a tech-related product. And one of the first questions I asked them, hey, did you think about IP? Many have not, surprisingly. But the comment that I often get is, yeah, we work in such a niche. There will be no interest in copying our product, which I mostly don't agree with, but I was wondering how you see that.
Many, many years ago, I was working in my own business, working for a client who developed the plugs, the wall plugs that you put into a wall, the little plastic round wall plugs into which you screw a screw so you can hang things on the wall. And it's just a wall plug, a simple little device, but they held intellectual property rights in that particular product. So and they asked us to assist them to enforce those rights. So who would have thought that a simple wall plug would be something that would attract anybody's attention? And so the answer is, yeah, as I think you know, anything, no matter how unique or unusual, if it's a good idea, then it'll attract attention. And to safeguard that idea and the intellectual property rights in it, yes, it's you can't take the stance that it's too unique and nobody will bother with it. That's simply wrong, and that's a recipe for losing the market quite quickly. If it takes off, sooner or later you would want everybody to know about it anyway, because it's the best product and it's won a segment in the market. So that means it will become well known by definition. So whichever way you look at it, it really is essential to obtain and register intellectual property rights in those products.
Thank you very much, Simon. I think we can close the